If you received letter 3172, the IRS just did something that earlier letters in the collection sequence only threatened. It made your federal tax debt public. And for a business owner, a federal tax lien doesn't just sit quietly in the file or in public record. It can potentially freeze your ability to borrow, block the sale of your business, and interfere with your own receivables. But it also comes with a 30-day right that many people don't realize they have. In this video, I'm going to show you more about what this letter really does and how to fight how it's handled. So first, let's talk about an important distinction that oftentimes trips people up and is confusing. The federal tax lien itself arises automatically. The moment the IRS assesses a balance and you don't pay after a demand, a lien, it's often called a silent lien, exists on all your property by operation of law. But what letter 3172 announces is that the IRS has now filed a public notice of federal tax lien. It's an actual document recorded in the public record that tells the whole world, and especially your creditors, that the government has a claim on your property, essentially everything you now own and everything you acquire later. But one of the most common confusions is that a lien is not a levy. A lien is a claim. It essentially secures the government's interest. It's telling the public you owe them money. Whereas a levy is an actual seizure, actually taking the money or property. That's letter 3172. It's about the lien, the public claim. It doesn't mean, just by this letter alone, that the IRS is grabbing your bank account today, but it does potentially cause other damage. And here's what a public lien, specifically a public federal tax lien, does to a business specifically. It can block or complicate a business loan, line of credit, or other borrowing because lenders will pull your record and they can see that the IRS is ahead of them in line to be paid. It could also potentially kill the sale of your business. Any serious buyer and their lender will find the lien during due diligence. It can also interfere with factoring or borrowing against your receivables because the federal tax lien can oftentimes jump ahead potentially of a lender's interest. And it also attaches to business assets, all your other assets you might have. And if you happen to be personally liable and the IRS files a federal tax lien against you personally, that attaches to all of your personal assets. So your home, accounts, any personal equipment, or other types of assets you have. So for a lot of owners, the potential credit and financing damage could be as damaging or more damaging than an actual levy. But let's now talk about the right that comes with letter 3172. It gives you the right to what's called a collection due process hearing, also sometimes referred to as a CDP hearing, but only if you request it within 30 days of the date on the notice. And you use the same form to request a hearing, Form 12153, as you would for a levy notice. And in that hearing, which is an informal conference with an appeals officer, you're not arguing about the debt itself generally, but you can discuss specific lien relief that actually keeps your business operating. So there are kind of 4 lien tools you can use, and let's go through them quickly. One is withdrawal of the notice of federal tax lien. And this is where the IRS removes it as if it were never filed. This can happen if the IRS was in error with filing it, and this essentially cleans up the public record like it never was filed. You can also apply for a discharge. So a discharge frees a specific asset from the lien, for example, so you can sell a piece of property with the proceeds going towards the IRS debt. This lets you sell a piece of property to pay down the IRS. Otherwise, with the lien still attached, a buyer might not want to purchase it because they wouldn't have clean title to the asset. There's also something called subordination. So this doesn't actually remove the lien, but it lets another creditor move ahead of the IRS. And this is sometimes the key to getting a loan or refinancing to help pay the IRS back. And then finally, there is a release, and that removes the lien entirely once the debt is satisfied or otherwise resolved. So if you end up paying back all of your debt, the IRS will issue a lien release. So each of these is actually a real powerful option you can use, but they're a strategy, and your entire situation has to be taken into consideration. And that's where a professional advisor is really valuable. So when you get a 3172, these are the moves you want to make. First of all, confirm the balance and that every tax return is filed. Make sure you mark on your calendar the 30-day CDP hearing deadline and decide what lien tool, such as withdrawal, discharge, subordination, actually fits what you're trying to accomplish, or if there might be other options available in the CDP hearing as well. Sometimes you can argue the underlying tax debt if you haven't had an opportunity to contest it before, penalty abatement, or other collection options. And you need to make sure it fits what you're trying to accomplish, whether that's protecting your credit, closing a sale of your business, landing financing, or just paying the IRS back in a reasonable manner. So really, the bottom line on Letter 3172 is that the lien is public and it could affect your ability to do business. But, and most importantly, you have a 30-day window to fight how it's handled. Withdrawal, discharge, subordination, other options are genuine tools, but you need to make sure you move early and strategically. So, if you receive a Letter 3172, act quickly, and if a lien is threatening the sale of your business or pending sale, that's the moment to bring in help right away before that 30-day period runs. So thanks again for tuning in. If you found this video helpful, please make sure to like and subscribe, and I'll see you in the next video.